The most important part of my practice when I was in Millersburg was oil and gas. About a year after I opened my law office, there was a small oil and gas boom in Holmes County. And I started out representing farmers who showed up in my office complaining about the oil and gas people polluting their farms or having a cow drink some polluted water and killed the cow, or cases of that sort. And I was such a pest to the oil and gas guys, the next thing I know, they're hiring me to be their lawyer and defend them against these kinds of claims. And my favorite client was Gene Smith at Bands, who was a real character and clearly an alcoholic, but Gene was forever getting himself in trouble. My favorite Gene case was one day I got to the office and my secretary said, "David, you got to call Gene Smith right away." So I called Gene. He says, "David, I've got 3 of the maddest township trustees you ever saw in my office, and I'm sending them down to your office, and in 2 minutes I'm going to call you and tell you what's going on." I said, "Okay." Well, 2 minutes later, Gene calls back. He says, "All right, here's the deal. You know how difficult it is to set up and tear down a rotary rig." I said, "Yeah." He says, "It takes about 3 days to set it up, about 3 days to tear it down." So we had a rotary rig that had just finished drilling on the Miller farm, and we needed to move it about half a mile down the township road to the Yoder farm. And so instead of tearing it down, why, we just hooked onto that son of a bitch with with 6 D6s, 6 big bulldozers. And we just skidded it out of the field, down onto the township road, down the township road. And when we got to the little bridge over the creek, why, the boys just got out the cutting torches and took the sides off that bridge so that we could pull it across the creek, and we pulled it across the creek, and then they got out the welders and they welded the sides back on the bridge. I mean, no problem. And then we took it on down to the farm, one of those township trustees managed to come along this morning before we got a chance to paint the damn bridge, and he noticed what had happened, and he figured out that we're the ones that did it, and he's there. Well, he said, "Now you got to just calm him down." He said, "You got to just calm him down." So I got to talking, and he was right. These were 3 of the maddest township trustees you ever saw, and furthermore, their legal counsel was the prosecutor, and at that time my law office was in a little house. I was on the 2nd floor. The prosecutor was on the 1st floor. If those guys had gone to talk to the prosecutor, Gene would have been in jail in 2 minutes. But I talked to them in township trustee language. In other words, I talked to them in terms of loads of gravel. And we determined that it would be adequate compensation to the township if Gene would supply 120 loads of gravel. And I knew Gene had dump trucks, and so he could load up his dump trucks and spread a little gravel on the roads and make these township trustees happy. So I called up Gene and told him that I'd calmed him down and it was going to cost him 120 loads of gravel. Oh, he was just outraged. And when I explained to him that the choice was he could go to jail, why, all of a sudden that sounded like a pretty good deal. My favorite farmer with an oil and gas problem was Charlie Spade. And Charlie owned a farm, and it was on the edge of the Columbia gas storage field in northwestern Holmes County. And Charlie had for years been trying to get somebody to drill an oil and gas well on his farm, and he was sure that the Columbia Gas was getting in his way because they didn't want anybody drilling quite that close to the storage field. Well, finally, he managed to get a guy lined up to drill a well on his farm, and they did drill a well on his farm, and the well hit the storage field. It was producing the storage gas, or at least Columbia thought it was producing storage gas. And the guy that drilled the well, I mean, the last thing a producer wants to do is be in trouble with Columbia Gas. He cut a deal, and Columbia probably I think he got, what Charlie told me was that he got 2 oil wells for his one. Columbia gave him 2 of their regular oil wells that had nothing to do with storage. And so, but Charlie still had his 1/8 interest in this oil well. And so I wrote Columbia Gas a letter telling them that I represented Charlie and that we wanted assurances that he would get 1/8 of all the oil and gas that came out of that well. And
even after you'd been given 2 other wells.
No. The producer got 2 other wells.
Oh.
The guy that drilled the wells has 7/8 and pays all the expenses. The landowner gets 1/8 and no expenses, no deduction for expenses. And that's standard oil and gas leases in the state of Ohio. But Charlie wanted his 1/8, and he wasn't going to settle with Columbia. So one of the lawyers from Columbia called me up and said, "Look, you don't need to sue us. We'll help you work this out. We'll send somebody up to Millersburg. You can take a deposition. We'll stipulate that it's legit, and you can ask all the questions you want to ask." I said, "Well, that's very nice of you, and I appreciate that. But tell you what, in the course of taking this deposition, I'm just certain that there's going to be documents that I'm going to want to see, and I feel fairly confident those documents are in Charleston, West Virginia. So how about I come down to Charleston, West Virginia, and take this deposition?" He said, "Well, that'd be just fine." And so we scheduled a time, and I flew down to Charleston. That was about the last time I ever did that. It turns out you got to go through Detroit or Pittsburgh. It takes longer to fly to Charleston than it does to drive. So I flew down there that first time, and why the first thing that those guys wanted to talk about was a settlement, and they didn't. It was clear they didn't want me seeing any of their documents, which is kind of what I suspected would be the case. So I finally talked them into paying an amount that would be equal to twice the total royalties that a landowner could expect on a really good Clinton well over a period of 20 years. It's paid all at once. And I called Charlie Spade, and I had to talk like crazy to get him to take twice as much money as he was ever going to make on this well right now and not wait 20 years. But I talked him into it. And what happened after that was 6 months later, Jack Snyder, the Assistant General Counsel of the Columbia Gas Transmission Corporation, showed up in my office. And he had made an appointment to come see me at 4:00 in the afternoon, and told me that he wanted to hire me as a lawyer for Columbia Gas in Holmes County. And it became clear that he was really checking me out. And I invited him to come to our home for a cocktail, and he timed it so that that sort of thing would happen, because I think he wanted to see, where's this guy live and what kind of family has he got? Well, apparently we all checked out, because the next thing I knew, I had a case down in Coshocton County, and it was Columbia had a lease that covered like 5 different pieces of property, totaling several hundred acres, and it was all being the oil and gas lease on it was all being held by one little Clinton well that was barely producing, and somebody sued Columbia to cancel that lease, and I called Jack almost immediately and said, Jack, we're going to lose this case. The facts are against us. And he said, well, you just fight them as hard as you can till you get to the courthouse steps and then settle. and so, and he was doing that for the legitimate reason of he didn't want people to think it was easy to push over Columbia and take away their leases. And the next thing I know, I'm representing Columbia all over the place in Ohio. Any place in northern Ohio, I'm representing Columbia. Then I was engaged to represent them in the first of what turned out to be an entire string, I don't know, 30 or 40 cases having to deal with underground gas storage. The gas company has a problem. The problem is that consumers only want gas in the wintertime. They don't want very much gas in the summertime. At that time, 85% of the gas burned in the state of Ohio came up 4 48-inch pipelines from Shreveport, Louisiana to Frankfort, Kentucky. And from Frankfort, Kentucky, that gas was distributed by Columbia to 17 states in northeastern United States. And most of those states, 100% of the gas came up those pipelines. And they were in those pipelines 24/7, 365. So they got to have a place to put the gas in the summertime. And what they do is they take old gas production fields and reverse the wells and pump the gas back into these old production fields in order to keep it during the summer. And then in the wintertime, all they have to do is turn a valve and the gas comes flowing right back out. But the problem is that they don't own all the leases. On 95% of the land above these storage fields, the Columbia has the right to store the gas pursuant to an oil and gas production and storage lease. But they don't have the right for all the farms over the storage fields. And so and at that time, the price of gas had gone to $7 an MCF, so that it was really encouraging producers to go find where the Columbia didn't have a right and then try to drill a well. And Columbia would watch the applications for drilling permits like a hawk to see when somebody applied for a drilling permit inside one of their storage fields. And
if you have a permit inside of on top of somebody else's storage field, and you drill down, is that your gas or is that their gas?
Well, that was one of the problems. Now, they would argue, the producers would argue, and courts had held at this point, that it was just like the Columbia had returned the gas to nature, and it was just like a deer running across your farm. It runs across your farm and goes to the next farm. It belongs to the next guy. And if you drill a well, and the well is sucking gas out from under your neighbor's farm, as long as you're on a drilling unit that was the law. And if you got Columbia storage gas, so much the worse for Columbia. So the Natural Gas Act says that interstate gas transmission corporations regulated by the Federal Energy Regulatory Commission, which is what Columbia was, have the right to lay interstate gas transmission lines and appurtenant pressure facilities. 3 words: appurtenant pressure facilities. We took those 3 statutory words and claimed that Columbia had the right to appropriate underground natural gas storage easements beneath farms within the storage area. One of my fondest memories of practicing law was explaining underground gas storage to Judge Dowd in the federal court in Akron. And, I got a wonderful federal judge on the bench, great big beautiful federal courtroom, 2 Columbia Gas vice presidents in the back of the room. And by the luck of the draw, we filed 2 cases at once. One was in Ashland County, and that case should have been heard in Akron. The other, I think, was in Medina County, and it should have been heard in Cleveland. Well, by the luck of the draw, both of those cases got assigned to Judge Dowd. And he realized that we were going to make new law on this subject, and that all of the cases on the subject ought to be heard by the same federal judge so that whatever was done was consistent. And he put on an order that all of my Columbia Gas storage field cases should be assigned to him. And that was just a wonderful thing, because he was a wonderful judge and I really enjoyed working in front of him. Now, every once in a while when I was trying a case in front of Judge Dowd, I'd get a little bit off the track and he'd look over the top of his glasses and he'd go, "Mr. Noble, who do you think is in charge of this courtroom?" "Oh, well, now that you put it that way, Your Honor." But one of the jobs of a trial lawyer is to push the edges of the envelope, and to see just how far you can push. And the job of the judge is to tighten up the reins a little bit. and Judge Dowd understood that. So as long as I responded appropriately, we got along just fine. But
did you have any qualms about these people, these farmers who you've been representing and beating up on Columbia Gas and then suddenly flipping on them?
Well, I didn't flip on anybody that I had represented.
No, but you did flip on the side of
Yes.
the farmer versus the company.
And that sort of thing is just fine. There's no there's no problem about that. I mean, I did a little bit of prosecution, a great deal of defense work in criminal law.
Does that get back to the question of representation? Everybody deserves a lawyer, whether it's
Yes.
Columbia Gas or a beleaguered farmer.
Yes, or a beleaguered defendant in the criminal case. Yes, everybody's entitled to a lawyer, and yes, representing Columbia Gas was far more lucrative than representing any of these other people. Well, I'd be fair to say it educated my children. It was wonderful work. They had a wonderful legal department. They had terrific lawyers to work with, and I drove up and down Interstate 77, going from Millersburg to Charleston, or then from Cleveland to Charleston. And
it's a nice drive.
it's a magnificent drive. It's 86 miles from Marietta to Charleston. And I never did find out how fast one has to go to get a ticket in West Virginia. And I always made that trip in less than an hour. Oh, another case I had for Columbia, for an underground gas storage case, was the Spielman case, which involved a 58-acre farm, and they hired an oil and gas petroleum engineer who testified on deposition that there was $7 million worth of oil and gas beneath that particular piece of property. So it was clear to me that their bright idea was that Columbia should pay them $7 million for appropriating the property, the oil and gas rights on that farm.
Is this also an underground storage
Yeah.
question? Yeah.
Right. We're appropriating the underground gas storage field, which means that there can't be any drilling on that farm, and they're not going to be able to produce the oil and gas that's beneath the farm, whatever it might turn out to be. The chances that it was $7 million worth is fairly remote, but that's what this guy testified. So on at trial, this expert took the stand, and I got to voir dire the expert. When you have an expert witness, you're entitled to, the opposition is allowed to ask questions about whether or not the guy's really an expert. It doesn't make a matter of difference whether it's a physician or an engineer or whatever. And I had developed a way of cross-examining experts based on my experience with Dr. Deming back on the railroad case, because he taught me a fair amount about statistics. And whoever the expert is, I get up and say, so do you know something about the mathematics and science of statistical sampling? Well, yes, I do. So you're aware then that when you do statistical sampling, you calculate a standard error, yes? And the purpose of a standard error is to determine the reliability of the study, yes? So tell me, have you ever calculated a standard error for your opinions to determine their reliability? Now, no further questions. You know? So, ladies and gentlemen of the jury, how can you rely on this if they haven't calculated, if they haven't determined the reliability of the? It's nonsense, but nobody's fast enough to figure out that it's nonsense in the pressure of a courtroom. Now, I started asking this guy some questions about statistical sampling and reliability during voir dire. In fact, to the point that Judge Dowd said, Mr. Noble, let's let Mr. Smith do direct examination and you'll get an opportunity to cross-examine. Oh, when the judge thinks that, I think it too. So I sat down, and the opposing counsel went through his whole spiel and finally got to the important question: do you have an opinion based on reasonable petroleum and engineering certainty how much oil and gas is beneath this particular piece of property? And the guy said no. I'd scared him. I'd scared him so much that he did not want to face cross-examination, and so he just said no. The judge says, so Mr. Smith, would you like a moment to talk to your witness? And he said, well, yes, I would, Your Honor. The judge said, well, Mr. Noble and I will be in my chambers trading war stories while you talk to your witness, and you come talk to us, tell us how it went. So we're back in chambers. Pretty soon Smith comes back and he says, the judge says, so have you figured things out? He said, no, he will not testify. And the judge says, so do you have anything else, any other evidence of value? And in federal court, the property owner has the burden of proof as to value. And if he has no evidence, the judge has to award $10. So he said no, and the judge said, well, let's go back and get on the record. So Smith wanders out to the courtroom. Judge Dowd is headed out the door, and I stand back and let him go first. And he turns around and he looks at me and he said, well, now, Noble, you've made a really mess of this case, haven't you? And I said, tell you what, and what he really meant was he didn't want to order $10. That was just not fair. I said, Judge, I'll stipulate my evidence of value so that there's a decent sum for you to order. And I did, and that made Judge Dowd happy. No, you got a federal judge you work with a lot, you want to keep him happy.